Welcome, everyone. Hopefully you can all see the slides now. As she mentioned, I am Timothy Michaels Johnson. I am the Executive Director of Tulsa Lawyers for Children as of May 1st. Prior to being Executive Director, I was a prosecutor in Tulsa County for 5 years in deprived cases, and then I've now spent 4 years representing children. I was the senior staff attorney before taking on the position as executive director. For those of you that aren't aware, Tulsa Lawyers for Children is a nonprofit here in Tulsa County that represents abused and neglected children when they are placed in DHS custody. We primarily do this by training and supporting volunteer attorneys to do the representation, but we also have staff attorneys that represent children when we don't have volunteers available. So today I wanted to discuss with you all how attorneys can actually be helpful to social workers. I know that in my experience, social workers have a tendency to look at attorneys as the enemies of their efforts to either reunify families or to protect children. And so I've worked, looking at the list, there are quite a few of you that are attending today that have worked with me in the past. And I very much appreciate the opportunity to work with social workers. Child welfare is a merger of both the legal side of an adversarial side of the system, but also merges that with social work, which is absolutely important and appropriate for reunifying families. We are a very specialized court in that we provide services to help fix problems rather than punishing or finding ways to make something right for something that has happened. We simply try to find ways to make things better. But neither side, neither social workers nor lawyers can do this on their own. Without the administration of the courts and the statutes that indicate how we go about providing due process to our parents and to our children, the social work would not have a place to go. And so, likewise, attorneys do not make good social workers. That is not our job. That is not our forte. We like to argue far too much to assist others in finding ways to resolve their own problems in that sense. So we have to work together. I know there's been a lot of talk recently in the recent years about creating multidisciplinary teams. It is a system that I would like to see utilized more often in child welfare. In particular, there are children's attorneys in other states that actually have a multidisciplinary team in place where the firm itself has not only attorneys on staff, but also has social workers on staff to help those attorneys work with their clients and ensure that services are appropriate and that they're working well towards the most appropriate permanency plan for a child. While we don't have that in place right now in Tulsa or in Oklahoma, I think that it is absolutely appropriate to consider the attorneys that are representing the clients in these cases and the social workers that are involved in these cases as a team itself, and that we can find ways to work together to push a child's permanency forward. But in order to do that, it is of the utmost importance that everyone understand the roles and the interests of those that are involved. In particular, for social workers, it's sometimes difficult to determine what an attorney's role is and what their interest is. What are they focused on? So I've wanted to break it down. There are 4 primary attorneys that are going to be involved in these cases. The district attorney, the child's attorney, the parent's attorney, and the judge. Let's not forget that the judge is himself an attorney or herself an attorney also. So for the state of Oklahoma, the client of the district attorney is the state of Oklahoma. They have a responsibility to protect children under the 18 years of age, and that is their primary interest. That is their primary goal in these deprived cases, to provide that protection within the law. Their role by statute is to prepare and to prosecute all of the hearings under our child welfare statutes, Title 10A. And so that is their primary role in these cases. Now, I think it's also important to realize the sources of information that these different attorneys receive their basis for their arguments and their opinions. For the district attorney, having been one myself, they primarily rely on permanency worker reports. They rely heavily on communication with the permanency worker. They also will actively look for information from tribal workers to assist, especially in those ICWA cases, on how the case can proceed or how the case can make progress towards permanency. They also rely heavily on CASA and the reports provided by CASA. And then they have to review the provider reports that are provided as part of the permanency reports. They also will receive information from foster parents, usually through foster parent reports, and they often will get information from other attorneys, in particular the child's attorney, the parent's attorney. The reason I point this out is primarily because of the nature of this work and because of the time-consuming nature of appearing in court. The district attorneys, the assistant district attorneys that handle these cases, rely heavily on the reports that are provided. They are not likely to reach out to individual permanency workers, to individual CASAs, to foster parents directly. They do not have the time or the energy to reach out to each individual to gather their own reports on information. So they rely heavily on what's provided to them by the permanency worker, which just expresses how important it is for those reports to be complete. They have to provide as much information as possible because they don't have the time to investigate it themselves. When it comes to their decisions and their advocacy, the primary thing in consideration for a district attorney in determining how they intend to argue a case or proceed with permanency for a child is they are focused on what they consider to be in the best interest of the child. That is largely informed by the information provided to them by the permanency workers. But they also have to take into consideration the legal authority. What do they have the power to do? What can they or what can't they do given the information they have? For a child's attorney, obviously their client is the child. There are two different methods for representation of children in Oklahoma: a substituted judgment and expressed interest. It is important prior to communicating with the attorney to understand, or sometimes you have to communicate to determine how they are representing their client. For a substituted judgment, the interest is what is in the child's best interest. That is going to be the focus of the child's attorney. They are going to advocate for what they believe to be in the child's best interest, and they will focus also on protecting that child's legal rights, even when they cannot express themselves their wishes. For those that do have the ability to express their interest, we do offer representation for those children on an expressed interest basis. So it is our job to meet with our clients, to determine their wishes, to determine how they wish to proceed in a case, and then it is our job to advocate for those wishes, to advocate for their expressed interest. This oftentimes can be confusing, and why it's important to understand how an attorney in a particular case is proceeding in that case, because the attorney, depending on the age of the child, could go either direction. I have had children of the age of 4 that I have represented expressed interest. It doesn't happen often, but there are some children that simply have a better understanding and grasp of everything around them, and can communicate and express an understanding of consequences and how they wish to proceed in a case. Whereas I have 6 or 7 year olds who generally would be an expressed interest, but they simply do not have the ability to comprehend and understand the case and what the consequences are of decisions that they wish to make. And it makes it very difficult for them to actually provide a position that they wish for you to proceed on their behalf. So regardless of age of the child, it's important that you communicate with the child's attorney to ensure you know how they are proceeding in court. Are they representing best interest? Are they substituting their judgment? Or are they representing the expressed interest of the client? Now, the default is expressed interest. It's one of those things that as an attorney for a child, we have to make a judgment call. We have to meet with the client. We have to talk with the client. And based upon that communication and based upon the information we receive from permanency workers, from therapists, and from other avenues, we have to make a determination of whether or not it's a substituted judgment case or an expressed interest case. And each attorney is going to handle that situation differently. So source of information. Again, we're going to rely heavily on reports from permanency workers, from tribal workers, CASA, service providers. We often have the ability to communicate directly with foster parents and do often. And so we have a little more leeway in receiving information directly from parties or individuals involved rather than just relying on reports. And then we also have our child client. We are responsible for meeting with our client, and if they are verbal, we need to take into account their wishes and their desires. That goes for cases that are substituted judgment. Even if I have a client who's 4 years of age, who I determine it would be a substituted judgment case, I still need to meet with that client. I still need to talk to them because their wishes, the things that they express to me, still inform what I believe to be in that client's best interest and how I'm going to advocate. And then we also receive information from state and parents attorneys as they advocate for their positions and try to gauge how they wish to proceed in a case. We receive information from them. And our decisions and advocacy are primarily based on the interest of the child, whether it be best interest or expressed interest. That is going to inform how we make our decisions. The parent's attorney, their client is the parent. They, just as I would with a child who's able to express their interests or their wishes, the parent's attorney represents the expressed interest of the parent. They do not have to, nor do they often take into consideration what is in a child's best interest. They will do so to make their argument stronger. They will certainly find ways to argue a child's best interest and try to formulate an interest for the parent that coincides with the child's best interest or with the parent's best interest. Whoops. There we go. And that their role is to advocate for their parents' wishes and to protect their parents' legal rights. I know in many conversations, not only with social workers, but often with foster parents, I received the question of why? Why are we having this hearing? Why is it being passed? Why can't we just terminate a parent's rights, or why can't we just send a child home? And it's because each party has a right to due process. And so there is a legal right to certain procedures and proceedings to occur in a case. And certain processes have to be followed in order to ensure that they receive those legal rights. And so oftentimes you will see parents' attorneys making arguments that are procedurally based rather than interest-based, because that's part of their job, is to protect that parent's legal right to the child. Their sources of information, again, they do have the ability to reach out to other individuals a bit more freely. But I find that they often rely heavily on the reports of permanency workers. Again, they're going to rely on the reports of the tribal and CASA, and they're going to look at the service provider reports. I will say most of the time, parents' attorneys are going to start making conversation or reaching out to individuals more as they proceed towards a trial, whether it be for an adjudication or a termination. That's when they start reaching out and touching individuals more so than reviewing reports. Now, their decisions, their advocacy in court and in these cases is going to be guided by the interest of the parent. That is always going to be their foremost concern in their advocacy. Finally, we have the judge. The judge is an attorney. They do not have a client. Their interest is the legal and constitutional rights of the parties, all of the parties, the children, the state, and the parent. And so it is their job to provide a fair and impartial venue for deciding legal issues involved with these cases. Now, by legislation, they are to consider and make foremost in their considerations what is in a child's best interest. But their primary role is to provide a fair and impartial venue for deciding legal issues as relate to the parents and the children. Their sources of information are far more limited than anyone else. They don't have the ability, nor should they be contacting individuals involved in these cases. Especially with regard to ex parte communication. They should not be having individual conversations with social workers. They should not be having individual conversations with service providers or with CASAs or any of the attorneys involved in the case. They are supposed to maintain the fairness and impartiality of their venue, their courtroom, by leaving the information provided to them to court hearings and court reports. That is to ensure that all information provided to the judge is provided to all parties. So I noted on here that they rely heavily on reports. And I will also note that I failed to put on here that in addition to reports, we have court hearings. And those court hearings are an opportunity not only to provide additional information or to provide additional support for information provided, but it is also an opportunity to provide arguments to help the court make decisions that are best for the child. And their decisions and advocacy are going to be based on the rights of the parties, ensuring that those rights are met, that the statutes are followed, and they are also guided by the best interest of the child. So when you have these cases and you are working with a number of attorneys, it is important to be able to identify who your allies are. But before you can do that, you need to know what your permanency goal is. Now, I have listed here a couple of recommendations for your initial point of contact, but they don't always hold true. So, reunification. Oftentimes, if you are trying to reunify a family, you are going to find a great deal of assistance and guidance from a parent's attorney, because that's going to be their primary goal. That is going to be the interest that they are going to be fighting for most of the time. Now, you do have to take in consideration that parents don't always agree. So if there's a mother and a father and you're trying to work towards reunification with mom, dad's attorney may not be the most appropriate person to turn to for assistance in determining how to get the child home with mom. But in reunification, you will also find a great deal of support from the state attorney, from the district attorney, as well as the child's attorney for the most part. There are going to be situations where either the state disagrees with proceeding towards reunification, even though the permanency worker wants to go that direction or believes that's the best way to go. And the same with the child's attorney. I have had cases where my client is adamant they do not wish to return home, but the default permanency plan in these cases is reunification, and if there's no reason to change that permanency plan, that is going to be the plan that DHS is going to be striving for. And in those situations, the child's attorney may not be the best person to turn to for assistance or guidance on the legal side of things. With regard to adoption, the district attorney, depending on the circumstances, the child's attorney may also be a strong advocate in working towards that permanency goal. And guardianship, the child's attorney is often the one pushing for guardianships. And I say that because it is one of the best options available to avoid a termination and still maintain parental rights if a child wishes to have those parental rights intact. But you will also find assistance from district attorneys and maybe even a parent's attorney if that's the most appropriate way to go, because it's a way to protect their rights, maintain their rights to their child, while still proceeding in a way that gains permanency for the child. It's also important to identify what the barriers are to your permanency plan. Is the parent themselves a barrier, or the child, the state, or the court? The court itself can sometimes be a barrier to proceeding with the permanency plan you have identified and are trying to work toward. So you need to know what those barriers are and identify who the individuals are that are part of those barriers, because that will influence who your allies are in the legal system as well. And I would also point out that you need to know your audience. This means to know the person that you're going to be working with and not just the position. So not every assistant district attorney is going to handle a case the same way just because they're an assistant district attorney. The same goes for children's attorneys and parents' attorneys. There are some parents' attorneys that would be very, very difficult to work with just because of their individual personality. And there are going to be some parents' attorneys that work very well with social workers and are very open to having conversations. So it's important for you to know who your audience is and how that you anticipate they're going to react to your approach. And I will point out, and we'll discuss a little bit further later, that the judge, him or herself, may also be an ally. Not in the same way, but they can still be considered an ally. So, how do you utilize your allies? Once you've identified who your allies are, which attorneys are most likely to be able to support your proposed permanency plan, you need to communicate with those attorneys. You need to communicate with them. Attorneys need information to do their job well. The better the information they have, the better the advocacy they can provide. So you have to talk to them. Don't rely on emails or just court reports to provide the information to that attorney. Call the attorney, schedule a time to visit with them, meet with them for lunch, but have that conversation. Talk about the case. If you don't put it on their minds, they have other cases, and those will take priority. Squeaky wheel gets the attention, gets the oil. The same goes for these cases. If a case is just going by and they're not getting information, they're not being provided updates from social workers or service providers, it's not going to be the focus of that attorney. So you need to communicate with them. But that communication is two ways. So when you communicate with the attorney, you need to also be asking questions. I mentioned here, attorneys love to poke holes in ideas. We love to hear arguments, hear plans, and find ways to show how they won't work. And you can use this, even with those that are not your direct allies. You can have those conversations with attorneys, and you can learn how to make your permanency plan even stronger by identifying potential weak points in your plan and finding ways to resolve those. Also, get clarification. When an attorney takes a position you don't understand, ask why. sometimes it's as simple as there's a statute that doesn't allow me to do X, Y, or Z. Sometimes it's going to be a bit more nuanced. It may be reliant based upon communication with their client, maybe based upon some additional disclosures that they received from their client that they can't share. But get clarification. Find out why an attorney doesn't agree with your position or is having a hard time taking a position you're asking them to. You should also, in communication with those attorneys, strategize with them. Discuss how the legal system, how the law, the statutes themselves may help you achieve your goal, your permanency goal for a family. There is a rebuttable presumption that reunification is in a child's best interest. So work with them to find out how you can emphasize that presumption for reunification, or discuss with them how you can go about providing enough evidence or information to rebut that presumption. Also, it's important to discuss with the attorneys what you as a social worker can do to help them help you. When an attorney is presenting a case, they need to have evidence. They need to know what information they have available to them to provide to a court to make a substantial argument that helps move that permanency plan forward. So you may want to talk to the attorney. What information do they need? What information can you help procure or provide to them to help them come to a position that is more aligned with your permanency plan, or that supports the permanency plan you agree on? Work together to identify potential reasonable efforts or active efforts that may assist in moving a case forward. There are cases where just having that conversation will help move a case forward significantly, because if there is a lack of reasonable efforts, or if there's a question as to whether active efforts have been provided, the case is going to stall. It is not going to move forward, either because active efforts aren't being made, and so we're not getting the reunification services necessary to make that family, to rehabilitate that family, or active efforts aren't being made and we're not going to be able to proceed with an adoption or guardianship because we can't show that we made the efforts that were necessary to try to rehabilitate the family. It may also be that in talking with the attorneys about how to get to your permanency plan, you may actually be able to determine different actions outside of reasonable or active efforts that you can take to help gather evidence or information that that attorney can rely on to make arguments for the court, to push your permanency plan forward. So this one is particularly important for those cases in which the attorney is antagonistic to your position. So even an attorney who is antagonistic to your position can be considered an ally. And it's in the arena of influencing the parties, influence the parents, the child, the state. So attorneys advocate for their clients. Seemingly, and I know I've heard this complaint many times from social workers, they seem to be ignoring the obvious. They seem to be ignoring how obviously inappropriate a parent is with a child, or they seem to be ignoring how this case should be proceeding. But that's their job. Their job is to identify what their client's interest is and to find ways to make arguments, and sometimes to ignore information to make their client's interests, to support their client's interests. But a good attorney also advises their clients. They will sit with their clients, talk to them about the case, advise them of what's going on in the case, and provide them with advice on how to proceed in a case. And this is where you, communicating with their attorney, providing them with information, providing them with what your perspective is on the case can help exert influence on the party themselves. So even when an attorney appears to be disregarding information you're providing, they should be, and most of them are, taking in the information you are providing and processing its impact on their client. This should lead, and most often does lead, to attorney-client conversations that will be confidential, but that may instigate necessary changes in behavior, or even, in certain circumstances, that parents expressed interests. By communicating with the attorney for a parent or the attorney for a child, you may be able to exert a change in perspective for the parent or the child to support your permanency plan. One example of this is a child client who expresses they don't wish to return home. DHS has a plan of reunification. They are pushing reunification. That is the direction that the court is wanting to go, but the child is objecting and standing in the way. By communicating with the child's attorney, the reasons it's in the best interest of the child to return home, by communicating with the child's attorney about different avenues or different services that might be available to make that transition easier, the attorney can then have those conversations with the client and discuss with them why they may want to consider changing their position. Also, there are times where DHS has reasons for moving forward with a permanency plan that is not apparent to a child's attorney because the information hasn't been shared. For example, there are times where foster parents determine that they are no longer able to provide care to a child, and there is a desire to maintain the fewest number of placements for child clients, for children. And so there may be an extra effort at pushing for reunification to avoid a child jumping from one placement to another, if it's safe and appropriate. Allowing for giving that information to the child's attorney, or to the child directly in some cases, can have a direct impact on that child's expressed interests. And it can potentially help with moving a case forward towards reunification. The same goes for situations in which a parent is asking for a jury trial and wishes to push things to trial when there's a request for a termination. You may be able to have the conversations with the parent's attorney about the impact that's going to have on the child, why you think pushing a case to jury trial is not going to be in the child's best interest, and the impact it could have on the parent's relationship with the child or the parent's relationship with future adoptive parents. And that information can get passed along by the attorney. And I have seen it happen in the past where it has had a direct impact on the client's, the parent's expressed interest, resulting in proceeding with asking for their rights to be terminated themselves. One of the final ways to utilize your allies in these cases is to utilize them in courtroom advocacy. But to do that, the communicating, the strategizing, the influencing can't happen for the first time in court. If the first time you are communicating with the district attorney about something that you want to see happen in that court hearing, it's less than likely to happen. When you get to court, the attorneys have almost always already spoken to their clients. They have already formed their positions, and the arguments are made in courtroom not to change the position of the parties, but to influence the judge and the decision that the judge is going to make. So if you haven't been doing that communicating, that strategizing, that influencing prior to the courtroom, you're not going to find a great deal of help or assistance in the courtroom itself. And I have seen this time after time in cases in which a parent's attorney brings up a solid argument about concerns about a social worker's efforts or lack thereof. And because of the lack of communication between the district attorney and the permanency worker themselves, there is no advocacy provided for the permanency worker. There is a lack of assistance provided to support the efforts that had been made and to make those arguments clear for the judge. So, in proper preparation, your allied attorneys, with proper preparation rather, your allied attorneys will be pushing the permanency plan for you. You will still have to provide the facts. You will still have to provide the court reports and the information that the judge needs to make decisions. But if you have properly prepared your allies by having that communication and strategizing and influencing the parties through their attorneys, your arguments are going to have a much stronger legal position as the attorneys argue on your behalf. Now, what if the district attorney, the child's attorney, and the parent's attorney all disagree with your position? I've seen this happen before. The first thing I would say is you may want to reconsider your position and ask why you're the only one that believes that is the way that needs to be the way to go. Second, you may still be right. Attorneys can disagree for different reasons. It may be that all the attorneys disagree with you, but they also disagree with each other. And you may actually be right. So you may want to look to the judge as your ally. And this is where I said, the judge is also an attorney. They may be somebody to consider as an ally, but you can't talk to them alone. You can't have ex parte communication with the judge. But you do need to keep in mind that the judges, most of them, read your permanency reports before a hearing begins. You, in preparing your permanency report, are going to have a direct impact on how that judge is going to come into that hearing. They are already going to have information before the hearing begins, before the arguments begin. And they are going to have your perspective because of those reports before they come into court. So when you're preparing that report, you need to know why the attorneys disagree with you. You need to know what their concerns are with the permanency plan you are proposing. And you need to prepare a report that has sufficient information to support your suggested course of action, your permanency plan. But it needs to be focused on the child's best interest. In order for you to convince a judge to agree with DHS over all three other parties in the case, you need to ensure that the judge understands how your permanency plan is in the child's best interest. I would, however, clarify, don't make legal arguments yourself. For the most part, you are not attorneys, and even if you are an attorney, you are not acting as an attorney in this proceeding. If there's a legal reason why your suggestion can't be followed, you have likely already lost. Do not make legal arguments. It will only frustrate everyone involved and often will make your permanency plan, your suggested actions, less palatable. So just keep that in mind as well. If you need other resources, consider talking with DHS Legal. They are not parties to deprived cases. They cannot get involved in deprived cases except under very extreme and limited circumstances. But it is still their job to assist and advise DHS workers when issues arise in your case. I know of at least one DHS Legal in Tulsa County that used to be a prosecutor. They know the law and they know DHS policy. So they may also be someone to go to communicate your issues with, and they may be able to help you determine how to proceed with your permanency plan to make it happen. Also in Tulsa County, we have DHS court liaisons. They are familiar with court procedures and the attorneys that often appear in court. And so they can also be an access point to attorneys if you don't already have a personal relationship with that attorney, and can also provide information on how the court intends to proceed or how procedures will take place to assist you in determining how you want to present your permanency plan. And finally, I will also point out a little bit of self-promotion here. TulsaLawyersForChildren.org. We do have a resources page. It is designed as a resource for TLC's volunteer attorneys, but it breaks down Title 10A, the statutes of Title 10A, into procedural sections. I feel and I hope that it makes it much easier to read and understand what is going to happen at a court hearing, and especially for those newer permanency workers that have not had experience in court, who don't know what to expect at a court hearing or what the judge is likely to ask. This may be an opportunity to review those procedures from the statute perspective to get some ideas of how to move forward. We are looking to add an ICWA resource to this as well, so that when you have those Indian child welfare cases, you can get some additional support and assistance with that. Now, it does require registration, but it's free. It's just a way for us to track how usable and useful our website is. But we would love to see more social workers involved in reviewing our resources as well. And if you have suggestions for additions, we are more than open to hearing those as well. So that is the end of my presentation. I hope that it is enlightening and will help at least guide some conversations in the future with attorneys that are involved in your cases, so that you can push the permanency plan you think is best for your children clients, so that we can find the most appropriate resolutions to some of these cases.
Thank you, Timothy.
Absolutely.
We're opening for questions, comments. I see that a lot of people here are very involved in this work, from what I can tell from their workplaces. So maybe somebody would like to share or ask, or open their mics or ask questions on the chat. Okay, we have a question from Jana from CASA, and she asked, what difficulty do you find when the parent represents themselves?
So a parent representing themselves, that's difficult for attorneys involved in these cases, not just the social workers. Generally speaking, as an attorney, I am not permitted to speak directly with a parent. They have representation, and so I go through their counsel. So I utilize that same influence piece where I communicate with the attorney's counsel in order for them to have communication with their client to hopefully get some changes. When the parent is representing themselves, it becomes far more difficult. Usually because this parent is representing themselves because they don't trust the attorneys that are appointed for them, or they just simply don't want to hire an attorney. They think they can handle it themselves. It becomes far more difficult because they don't often understand the legal system itself. And so they struggle even with how to present their own arguments and the information they want to provide. So working with them individually becomes very difficult, and often I try to leave that to the courts to have those conversations. I will still present my evidence and present my information, but I very much try to avoid having one-on-one conversations with those individuals because of the Sorry about that. Because of the, I don't want to be perceived as pushing them to make a decision one way or the other, because I have a client. And so I am always going to be advocating for what my client wants, and it could be considered inappropriate for me to be pushing that position with a parent that's not represented.
Thank you. Tracy, also from CASA, asked if you are actually available to meet with social workers or not, because she said that on the one hand, it seems like you have a very heavy caseload, but you also seem to encourage meeting.
So yes, it's true, especially for the district attorneys. They are in court a lot, and so it can be difficult to communicate with them. I still push for that individual communication to happen. It requires you to schedule a time, and it can't be something where you say, hey, let's get together tomorrow. You may have to schedule it further out. It will take time and effort to make those arrangements with the attorneys. But absolutely, it's wholly appropriate to have those conversations one-on-one, to have a phone conversation, to take them out to lunch or to go to lunch together. But it requires planning. You need to ensure that they have the time available to set aside to make that happen. And I think most of the attorneys that I am aware of and that I have worked with want to make that effort.
Thank you. Actually, somebody commented about knowing that you need to know how to work with the parent's attorney, because the one that she has to work with has regarded CASA as the enemy and has been very resistant to communication. It's been frustrating, to say the least.
Yes, there are certain parents' attorneys that they take their role very seriously, and they take that to the exclusion of everything else, which I think in some circumstances can actually do a disservice to their client, because it limits the information they're receiving in order to advise their clients and to make the best advocacy choices they can for their clients as well. So it hurts them as much as it makes it difficult for all the other parties involved. In those circumstances, oftentimes your best bet is to identify which attorney is your ally and work with them to see if they can assist in bridging that barrier. It may be that I know of at least one particular attorney that others have struggled with. There are other attorneys that have a very good relationship with that attorney. And so working with attorneys that may have that relationship may help bridge those gaps.
Thank you. I want to suggest that you undo the share screen so that we can actually see more people. Great.
Yeah.
Okay, thank you. So a question from Ashley: how would you recommend advocating for a child in care's wishes when their attorney has not met with it?
Yeah. So in that circumstance, there really needs to be a push for that attorney to meet with the child. There's now a Foster Children's Bill of Rights that was enacted 2 years ago now, I think, that says that a child has a right to communicate with their attorney. Oftentimes, the problem is not being able to get to their attorney because they're children, and they don't necessarily, even the younger ones, they don't know that they have an attorney. They don't know how to get a hold of their attorney. So as a CASA, as a social worker involved in the case, you may be able to help push that relationship with their attorney. You may be able to help set up a meeting with the attorney. For public defenders, so I feel like I'm pretty busy and I've got about 62 clients. Public defenders have about 200 to 300 clients. They are overwhelmed with the number of clients that they represent. So the best way to ensure that they are meeting with their clients, that the client has an opportunity to speak with their attorney, is to set up an appointment for them. you as a social worker may contact the public defender's office and set up that meeting yourself. My understanding is that they are more than willing to meet with their clients. It just comes down to time and effort. And if you know that there's a need to have that communication, then taking that extra step might be helpful.
Thank you. Does anybody else have any questions or comments? Would like to open their mics? Okay, one more question from Tracy. If we can't get a response from the child's attorney, what is a workaround?
I guess it depends on what the issue is with regard to that lack of access. So for the public defenders, I think you can actually make an appointment through their office. So calling the front office and asking to schedule an appointment may be a method by which you can do that if you can't reach the individual attorney. If it's a volunteer for TLC, let me know, and I will assist in that type of situation. If we're talking outside of Tulsa County, it becomes a bit more difficult. But sometimes it simply comes down to, at a hearing, letting the court know that this is an issue. If you can't get the client in to see their attorney and the attorney is not responsive, the judge needs to be aware of that. That is that attorney's responsibility. And so the court should be ensuring that the attorneys are meeting with their clients because it's statutory. As an attorney for a child, I am required to see my clients before every hearing. And so unless there's very good reasons not to. So if that's not happening and it's a problem, let the judge know. That's one arena in which you can make the judge an ally.
Okay, anybody else? Any more inside information on how to get hold of those attorneys? Seems to be an issue, but I can understand.
Yeah, in Tulsa County, a lot of times you can contact myself because I have pretty good contact information for just about everyone, so I can usually be helpful in that arena, especially if they're volunteers. But even with some of the public defenders, if you're having issues or concerns there, and we do have some contacts for other attorneys in some of the surrounding counties as well, if that's an issue.
Okay, unless somebody wants to say something else, I think we're going to wrap up. Thank you so much for this presentation, Timothy.
Absolutely. Thank you for having me.
It gave a lot of tips and a lot of very, very valuable information. I'm going to wish everybody a good afternoon, and I hope that we see you all soon.